Thank you very much. Good morning. Well, thank you, Governor, for that kind introduction. I'm very grateful to the International Association for Identification for giving me the opportunity to speak to you here at your annual conference. I spent about an hour this morning with 5 of your board members, including your current president. I learned a fair amount about the organization and your interests. I also learned that you've been in existence for 102 years, which is quite impressive, so congratulations on that. It's an honor for me to address such a talented group of forensic examiners. I'm excited to share with you what the Department of Justice is doing to help you advance the reliability of forensic science. One of the keys to using forensic analysis appropriately is to understand its limitations. You need to know what it means and also what it does not mean. I recently handled a criminal appeal myself up in the Fourth Circuit in which we had introduced evidence that the defendant's telephone had connected with particular cell towers. One of the disputed issues in the appeal involved the testimony of a telecommunications company executive. He had testified that the cell tower range was about 3 miles, and digital records established that the defendant's phone had connected with this particular tower. Now, the telecommunications provider routinely relied on these records. In the normal course of business, this was hard, solid evidence that required no analysis. A witness without specialized knowledge could introduce it simply as a custodian of the company's records. Knowing what factors influence the range of the tower does require special expertise. The range generally is imprecise, and therefore the exact location of the phone is difficult to determine from these records. Is there anybody here who has testified to cell phone records in a courtroom? Very common evidence that we routinely use. Given the limitations, though, we argued only that the records provided direct evidence that the phone was in the neighborhood or the area of the cell phone tower, and circumstantial evidence that the defendant himself would have been there handling the phone. Our case did not rely solely on that cell phone analysis, but it was relevant, it was true, and it was properly explained. Now, I've worked as a prosecutor for 27 years. I understand the critical role that forensic analysis can play in our criminal justice system. I know that forensic analysis can be used to exonerate the innocent as well as to convict the guilty. In my current job, supervising law enforcement components of the department is one of my responsibilities. And this gives me an even deeper understanding and appreciation of the work that you all do on the front lines in advancing forensic science. In the Department of Justice, we practice forensic science through our crime labs and our digital analysis centers. We fund forensic science through grant programs at the Office of Justice programs and elsewhere. And we are clients of forensic science in tens of thousands of cases we investigate and prosecute in court every year. Given the Justice Department's deep reliance on forensic science to carry out our mission, we strive to help support a standard of excellence. And our Attorney General, Jeff Sessions, has made it a priority to reduce violent crime and to improve public safety. The effective and proper use of forensic analysis furthers those goals. I've been inspired by the outstanding work that I've observed firsthand as a trial prosecutor and as a supervisor. I've met extraordinary forensic examiners, and I appreciate the expertise that they bring to the job and their dedication to justice. And I want to give you some examples. Recently, FBI forensic examiners undertook an initiative to re-examine old fingerprint evidence. They used the FBI's next-generation identification system to generate leads, identify missing persons, and solve crimes. In 1992, many of you may recall, Los Angeles experienced one of the deadliest riots in U.S. history. Many people, about 50 people, lost their lives, and one of them was a victim known as John Doe number 80. His body was found in a store that had been set on fire, but he was so badly burned that investigators were left with only a few clues about his identity, some teeth and a partial print from his left finger. For nearly 25 years, John Doe number 80 remained unidentified. But then an FBI latent print examiner had an innovative idea: to use the FBI's next-gen technology to run the fingerprints of unidentified individuals. This program relies on a sophisticated algorithm. Some of you may be familiar with it. It increases the accuracy and the likelihood of an identification beyond techniques that were previously available. Even where the FBI had already run someone's fingerprints, the latent print unit believed the new technology might produce new leads, and they were right. After 25 years, John Doe number 80 finally has a name. Thanks to hard work and technology, we know that John Doe number 80 was Armando Ortiz Hernandez. And that success story is just one of many. It doesn't stop with the identification of one individual. The FBI's latent print unit has partnered with a program funded by the department's National Institute of Justice, what we call NIJ. The National Missing and Unidentified Persons System stores information about thousands of deceased, missing, and unidentified individuals. And the staff of the FBI's latent print unit worked to run the prints of approximately 1,500 unidentified persons. As a result of that hard work, the FBI identified 195 deceased individuals, including 55 suspected homicide victims. One of those victims was a Virginia native named Andrea Cooper. Andrea disappeared 27 years ago. Through the new program, the FBI identified her as a woman who was killed in a car accident in California in 1990 and had been unidentified for almost 3 decades. Andrea's family now knows what happened to her, and many other families were able to experience closure because of that impressive latent fingerprint examination. Amanda's story and Andrea and Armando's story, those are just the beginning. You're developing new ways to use technology to advance forensic science and to benefit the criminal justice system. Last year, FBI lab personnel worked with database experts at the FBI's Criminal Justice Information System, we call it CJIS, to examine 42,000 unsolved crimes, including bank robberies, arson, and other violent crimes. All those prints had been examined previously, but FBI examiners thought they may be able to generate additional information using that next-gen technology. Running that many fingerprints required the FBI to develop a new interface to search large quantities of prints, and that effort paid off. The FBI generated leads about more than 1,000 suspects in previously unsolved crimes. Now the FBI is working to make that bulk searching interface available to all law enforcement agencies nationwide. With that new technology in the hands of our law enforcement partners, in your hands, many open cases can now be solved. Criminals will be brought to justice, future crimes will be prevented, and people will not become victims. None of this would be possible without forensic analysis. Without the creativity and hard work of professionals like many of you, there would be thousands more unsolved cases and thousands more victims waiting for justice. Dedication to finding the truth is the mission of our law enforcement professionals. That's why it troubles me when people unfairly question the integrity of fingerprint examiners and other legitimate forensic experts. The practice of forensic science relies on human interpretation of scientific tests and examinations. This is not new. Almost every applied science relies at some stage on human interpretation. That includes medicine, computer science, and engineering. A doctor who testifies about the cause of a victim's death bases that judgment on expert analysis. The same is true of forensic psychologists, entomologists, anthropologists, fire investigators, accident reconstruction analysts, and a host of other experts. They use their scientific knowledge and training to analyze particular facts and data. They apply judgment, and they come to a reasoned conclusion. Those disciplines have been around for a very long time. When subjected to informed cross-examination by qualified defense attorneys, expert testimony can be tremendously probative and helpful to the jury when offered by prosecutors, and of course it also can be valuable when offered by defendants in an effort to provide exculpatory evidence. But nevertheless, some critics have sought to limit forensic evidence and testimony. These critics suggest that unless a forensic discipline has a known error rate, evidence derived from that discipline should not be admitted in court. Now, under that standard, trusted and reliable forensic evidence would be excluded simply because the discipline is not susceptible to an easy-to-calculate error rate, such as we see in some hard sciences. Now, the folly of that approach becomes clear when critics question fingerprint analysis. And I talked with your board members this morning when the organization was founded in 1915. Fingerprint analysis was one of the leading issues that the association took up. The critics admit that fingerprint analysis usually works. Their objection is that it requires judgment. Well, those attacks are based on a mistaken view of the role of expert witnesses in our justice system. The bedrock principle of evidence law in our courts is that relevant evidence is generally admissible. Evidence is relevant if it tends to make a material fact more or less probable than it would be without the evidence. It's not necessary for the evidence to be indisputable in order for it to be admissible. For example, a shoe print with an irregular edge and unique wear on the outsole found at the scene of a burglary is likely relevant and admissible. Both the prosecution and the defense can use that sort of evidence to help the jury decide whether to believe a defendant was at the scene of the crime. Physical evidence may be more helpful to a jury if an expert can explain that evidence and place it in context, given that expert's experience with the methodology. The jury may benefit from expert testimony, for example, with regard to the shoe print, in interpreting how probative it is. Is it the same size as the defendant's foot? Does it match a shoe found in the defendant's closet? How common is that shoe pattern? Answers to these questions may determine whether the physical evidence is incriminating or exculpatory. But if the testimony were excluded, if the jury and the judge weren't permitted to hear it, the search for truth would be impeded. The jury would have no assistance in determining what to conclude from the discovery of that shoe print. So forensic evidence can be extremely important, but we also need to recognize that it can be abused and misused, as is true in every discipline. There have been instances in which people have operated in bad faith, masquerading as experts when they lack sufficient knowledge or failed to perform appropriate tests. In other instances, people have testified in good faith, but used language that may have suggested more confidence than was warranted by the evidence. But when the judicial system functions as intended, justice is advanced. Our adversarial system is based on the principle that the truth is most likely to emerge when opposing parties have the opportunity to cross-examine each other's witnesses, and each party is able to call its own witnesses and introduce conflicting evidence. Our criminal justice system provides important procedural protections for defendants. For example, a federal defendant is entitled to a written summary in advance of the trial explaining what the government's witness is going to testify about. That allows the defendant to know what the government's expert plans to say and to rebut it with his own expert testimony. The defendant also has the right to examine and challenge the results of any test that's going to be introduced in court. The search for truth benefits from those protections. But most of all, the search for truth benefits from prepared legal practitioners and trained forensic examiners. When courts exclude relevant forensic evidence, that undermines the cause of justice. Now, the Department of Justice has taken a number of steps to examine and strengthen the reliability of forensic science and its use in the courtroom. We're committed to improving forensic science and working with you to enhance public confidence in the extraordinary work that you all do. With that goal in mind, our National Institute of Justice has provided $125 million over the past 6 years for grants dedicated to research and innovation in forensic science. It will provide millions more this upcoming fiscal year as we continue to support your work. We hope that this money will lead to the development of accurate, reliable, cost-effective, and rapid methods for the identification, analysis, and interpretation of physical evidence. Federal funding has been key to earlier advances in forensic science, such as the Ames black box study of ballistics. Many state and local labs rely on funding from the department through our grant programs, and we are dedicated to ensuring that our state and local partners are able to access grant funds to conduct high-quality, reliable, and probative forensic examinations. The department is also committed to ensuring that our own forensic experts testify only in ways that are supported by the available research. Justice is not advanced if an expert exaggerates in describing the significance of the evidence. Now, to achieve that goal, I'm announcing today the creation of a new forensic science working group at the Department of Justice. Our first order of business will be to resume work on the uniform language for reports and testimony. I talked with your board members this morning, and I understand that's consistent with your initiatives and your thoughts about how we can improve forensic science. Our uniform language program started last year. It was paused earlier this year, but after discussions with department components and some of the relevant stakeholders, we've concluded that the project will help in setting the bounds of what examiners should say in court. Prosecutors and forensic examiners at the federal, state, and local levels support the project, so we have instructed our working group to finalize the uniform language program so we can implement it for department experts in the near future. We'll rely on input from outside experts, outside stakeholders, including your organization, and defense attorneys, academic scientists, and statisticians. But our effort will not end with the Uniform Language Initiative. I'm also directing our working group to establish a process to continually monitor the accuracy of courtroom testimony by our federal expert witnesses. The FBI has already implemented a monitoring program to help ensure that its experts testify accurately about the results of their forensic examination, so they'll have internal feedback about their testimony. A new department-wide monitoring program will ensure that all examiners give testimony consistent with scientific principles. This working group will be directed by our new senior advisor on forensics, and I'm pleased to announce that the Attorney General has appointed Ted Hunt to serve as our senior advisor. Some of you may know Ted. He's a teaching faculty member for a number of organizations that train legal practitioners, law enforcement, and laboratory analysts. He was previously a supervisory prosecutor in Kansas City, Missouri, and he's also a member of several forensic science commissions and organizations. Ted also served on the National Commission for Forensic Science, and appointing Ted to serve in this new position demonstrates the Attorney General's commitment to improving forensic science and supporting our partners in the law enforcement community in the extraordinary work that you do, because Ted will coordinate closely with federal, state, local, and tribal forensic science practitioners, as well as other stakeholders on the defense side, and he will help identify ways to conduct ongoing research and ongoing outreach to the stakeholders. And we're taking other steps to help you improve forensic science. In April, we announced a needs analysis of forensic laboratories. We plan to assess the workload, the backlog, the personnel and equipment needs of public crime labs, and the education and training needs of forensic science practitioners. As part of our needs assessment, we will first collect and review existing data sources. We already started reviewing materials to assess what data and information already exist and to identify what more we need to collect in order to achieve our goal. The next phase of implementation is to outreach to forensic science practitioners, and we welcome input from forensic practitioners, including all of you, about where additional resources may be needed. We plan to establish a needs assessment steering committee consisting of crime lab directors from around the country. We're going to convene that steering committee this fall and hold listening sessions with the committee and other forensic science stakeholders. Those listening sessions will explore forensic needs and ideas for ways that we can increase efficiency and expedite forensic analysis. The department will also conduct an internal needs assessment. The needs assessment for us is an opportunity to develop comprehensive strategies about how best to improve the reliability, quality, and efficiency of forensic science processes within the Department of Justice. I encourage you all to participate in our data collection to advance our shared mission of using forensic science to improve public safety. In April, the Department of Justice published an issue for comment in the Federal Register, seeking broad stakeholder input about how the department can best support the advancement of forensic science. We received more than 250 comments, including one from the IAI, and we're going to use those comments to help develop a path forward. It's a further illustration of our commitment. One of the speakers this afternoon at one of your breakout sessions is Kira Antel, who is a senior counsel at the Justice Department's Office of Legal Policy. She's been our point person on forensic science issues for several years, and she'll be speaking specifically about the Justice Department's commitment to advancing forensic science. Now, thanks to the diligent work of federal, state, and local leaders, there has been meaningful progress in advancing forensic science and in improving it and employing it in the legal system. We recognize that we need to use forensic analysis carefully, but we must continue to use it. We should not exclude reliable forensic analysis or any reliable testimony simply because it's based on human judgment. Has anyone seen the movie My Cousin Vinny? It's a classic. I tell my kids, it's not exactly what lawyers do, but it gives you a general idea. In this film, there's a young woman who takes the witness stand. She's a surprise witness, and some of you are too young to have seen this when it was in theaters, but this young woman takes the stand, and she's a defense witness. The prosecutor is very skeptical because she has no higher educational training, but she surprises everybody by demonstrating her expertise about automobiles. It doesn't necessarily take a PhD to be an expert witness and to provide information that will be helpful to a jury. There's some disciplines where it does, but not all. And it certainly doesn't require proof of a known error rate. Many factors may influence the weight of the evidence, how much the jury should rely on it. But we can count on juries to make those decisions as long as the witness is competent and responsible, and the judge gives appropriate instructions about how to evaluate the testimony, and the opposing side has the opportunity to cross-examine and to offer conflicting evidence if they have it. We face many law enforcement challenges, new challenges spawned by the internet and modern technology, old challenges like combating violent gangs, and evolving challenges such as the unprecedented surge in drug overdose deaths from synthetic chemicals. And I spoke with your board this morning about the challenge that some of your labs are facing dealing with fentanyl and other extremely dangerous substances that are arriving now for analysis. The President has tasked the Department of Justice to address those challenges, and the Attorney General strongly believes that we can find solutions by working in partnership with our forensic science community. Our Uniform Language Initiative and our continuous monitoring program will provide assurance that forensic analysis is used correctly. That will advance the search for truth in federal courtrooms, which is something that we are all committed to. So in closing, I want to thank you all for your commitment to responsible forensic analysis. I look forward to working collaboratively with you to ensure that reliable forensic evidence is available in our courts. And I was very grateful for the opportunity to meet with your board and to meet here with all of you this morning. We know the truth is out there. And working together, we will help judges and juries find it, and we will make America safer in the process. Well, thank you very much. It's an honor to be here.